A very good evening and welcome once again to PW OnlyIAS English. For those of us who are joining us for the first time, this is another lecture under the Udaan series for Prelims 2025. We are covering all the books of Udaan for Prelims 2025 revision. In this series, I'm going to present you Indian Polity lecture on federal dynamics in India. We are going to talk about the linkage between static and current affairs insofar as this topic is concerned, what is governor's role, how center and states cooperate in the arena of federal dynamics. What are the unitary features of Indian constitution? What are the federal features? All these topics are going to be discussed. Well, let us begin with the small tip. Whenever you are revising polity on your own also, you have to take the static along with the current. For example, in today's newspaper, Tamil Nadu governor's issue has appeared. So, under Article 200, what are the options available to governor? Governor can give the signatures on the bill, assent to the bill. He can withhold the assent. Number 3, he can refer the bill to the president. He can reserve the bill for the president's consideration. Now, this is appearing in the newspapers these days. But you are expected to go one step beyond and check the news clippings if there is any time limit for the governor to give the signatures. No. Okay, you have to have a definite answer. Second, what are the options before the governor if the president sends back the bill? So this is how, when you are interlinking static and current, you will be able to see that your score in whatever mock test, mock series, be it of OnlyIAS or any other prelims mock series you are attempting, your score will go up, your at least correct rate will go up. The number of questions you are answering right will go up definitely. So this is how you are supposed to take static and current alongside. Now, let us have a look at the questions, how the questions are being asked on this topic. Consider the following statements. The executive power of the Union of India is vested in the Prime Minister. Then the Prime Minister is the ex officio chairman of Civil Services Board. Okay, UPSC we are talking about. Civil Services Board. Is he the ex officio chairperson or is it the cabinet secretary? Those type of things you are required. So this question was not strictly in the realm of federal relations. Let us have a look at the other question. Which one of the following is not a feature of Indian federalism? A, there is an independent judiciary in India. B, powers have been clearly divided between the center and the states. C, the federating units have been given unequal representation in the Rajya Sabha. Which one of the following is not a feature? Then it is the result of an agreement among the federating units. So here what is required is not the knowledge. Everyone knows that there is All India Services, then there is integrated judiciary, unitary powers, etc. But the correct application of knowledge and attentiveness to the keywords, whether what is being asked. Okay, I might start a MCQ series also in which we can have these type of MCQs, and I would get a chance to, to tell you how to be attentive to these things. Read the question once again, at least the headline of the question, while marking the actual answer in your prelims. So this is what my endeavor would be to guide you. Now coming here, 2014, consider the following statements. The president shall make rules for the more convenient transaction of the business of the government of India and for the allocation among the ministries of the said business. Well, me being a polity teacher, I can recollect the article also. This is Article 77, under which all the ministries and departments are created, right? Now, all the executive actions of the government of India shall be expressed to be taken to be in the name of the Prime Minister. It is the President, right? Again, the question is on the boundary, I would say, not strictly in the arena of federal relations, but we have certain topics where this type of a question has been asked. Now, which one of the following articles of the Constitution of India says the executive power of every state shall be so exercised so as not to impede or prejudice the exercise of the executive powers of the Union? So, Article 257, 258, 355, 356. 356, President's rule is there. Then 355 is, it is the duty of the government to protect the states in case of any anti or unconstitutional governance, etc. Now the confusion remains between 257 and 258. Please do answer these questions. I have eliminated 2 for you. Answer is from 257 or 258. I would be looking for the answers in the comment section for sure. Now, The Parliament 2016, the Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by the A. Lok Sabha by a simple majority, B. simple majority of its total membership. Now you again have to be very attentive to details. Even if you have read thoroughly, if you miss out on any of the keywords like I demonstrated, I was not reading the full sentence. Sometimes in the rush to attempt or complete our paper, because these statements are quite longish sometimes, we end up reading half the statement, thinking that the remaining statement would be as usual given in the Lakshmikant or in our class notes. So be careful about those silly mistakes. Now, Lok Sabha by a majority of not less than 2/3 of its total membership. Okay. Then Rajya Sabha by a simple majority of its total membership. Rajya Sabha by a majority of not less than 2/3. See, the statements have been so arranged that you get carried away. Okay. By the time you reach the last part, you have lost many of you who suffer from this impatience or panic thing in the exam, you would end up marking C most likely. Even if you are very patient student, very somebody who gives attention to the details, but if you have some iota of panic thing in the examination hall, the exam anxiety, then you might end up marking, if not A, if not B, B, then at least C. Still, I would suggest read all the statements. This is where the mistake happens. From me also, the mistakes have happened like this in the preliminary exam, right? But luckily, I was able to clear every time. Now, the Parliament can make any law for the whole or any part of the territory of India for implementing international treaties. A, with the consent of all the states, with the consent of majority of states, then with the consent of the state concerned, without the consent of any state. So this again seems to be this thing. Okay, let's draw some context thing. Teesta River Water Treaty. Okay, international treaty we are talking about. Okay, Parliament can make any law. Parliament can make any law. Land boundary agreement. Did it require the consent of the West Bengal government when we signed Bangladesh Treaty? Land boundary agreement for exchange of 111 enclaves. Did it require that or not? Okay, so this kind of a thing can be very well understood from the current affairs. Now, please answer the question to this. I want you to look back into that thing and come back and answer the question with all the sincerity. If I will divulge the answer, you would not have the inclination to check it back for you. And when you check it back, don't be Arjun. Don't look for the eye of the fish only. Look around for some more knowledge. Right now, contents, these are the contents: Indian federal system, center-state relations. We are going to cover till this point today, maximum till this point 3. I have divided this series center-state relations into 2 parts, federal system into 2 parts for better clarity, for more time. Okay, so that your absorption capacity is good enough. Otherwise, if I will complete it in one lecture, you would end up losing the steam until the last leg of the lecture. By the time we reach the last part, 45 minutes, 1 hour or 1.5 hours, so you would lose the energy to absorb further. So that is why we'll cover till this point today, and in the next class we'll be covering this thing, right? Now, Indian federal system based upon Canadian model in its references as union. So we have borrowed this reference as union in its references as formation and centralization. Okay, so this knowledge can be used for mains also, comparison of Constitution of India with the rest of the constitutions of the rest of the world. Now, Canadian government is a federal parliamentary system under a constitutional monarchy. But it was formed by the method of disintegration and vesting more powers with the center than with the states. Since the basic polity has been exhausted by UPSC in terms of scope of getting more questions, unusual questions, so that is why, to be on the safer side, I have incorporated this brief information about Canadian model of federalism and India. Now, and the Indian one. States cannot frame their own constitution. Yes, constitution can be earlier Jammu and Kashmir was the exception, but not any longer. Now, constitution can be initiated and amended only by the parliament. Constitution amendment can be initiated and amended only by the parliament. Union list contains important and more number of subjects than the state list. So this is a general statement. Okay, the number of subjects we usually are used to 61 subjects, 97, those things when not given, are you still able to arrive at this conclusion? Very easy, yes. Parliament can legislate over any subject in the state list without amending the constitution if Rajya Sabha passes a resolution to that extent. Which article is it? Articles help you memorize the text of it. 249. Centre has overriding powers with respect to the subjects in the concurrent list. Residuary powers are vested with the centre. Residuary powers, service tax, entry number 97, if I remember correctly, was identified later on. Today, services sector has become an important contributor to GDP. Yet, services was identified as residuary subject. Can you imagine? A residuary subject today is contributing a lot to the centre's revenue. So this is there. Goods and services tax now is integrated. That's a different story. But until the arrival of GST, centre was getting all the revenue from services tax, right? So this is there. Now moving further, indestructible union of destructible states. Name, boundary and area of the states can be changed by the parliament at any time by a simple majority, and this will not even be considered as an amendment to the constitution, right? So such is the nature of our constitution, federalism in India. States are represented in Rajya Sabha in proportion to their population. So states, northeastern states are at a disadvantage over here also and in Lok Sabha also. Unlike in US where the 50 states get 2 members in the House of States, Council of States, right? In India, they get seats according to their proportion. So this is a disadvantage for the less popular states. Head of the states, the governor is not elected, rather appointed by the centre and holds the office during the pleasure of the president. Unitary features these are: the governor can reserve the state bills for the consideration of the president, who has the absolute veto over the bills. So governor can reserve any sort of bill. Okay, so this is there. Indian citizens have only one citizenship and no separate citizenship of the states as in US, Australia, etc. So which articles deal with it? Articles 5 to 11. We have studied this earlier in the series of our Udaan lectures only. Okay, now unitary features. India has an integrated judiciary enforcing central as well as state laws. Madras High Court for Tamil Nadu High Court, then Rajasthan High Court, Jodhpur bench, Jaipur bench likewise. Okay, so high courts and the judges of the High Court are promoted to Supreme Court. This way the judiciary is integrated. There are no separate state, there are no iron wall or China wall type of separation. There is no separation, such separation in the state judiciary and the federal court in India. So that is another unique feature, unitary feature of our system. Central government appoints the members of the election commission, even though it is called as Election Commission of India, but the way the members are appointed, it seems more like Central Election Commission. That is what the members are also named, Chief Election Commissioner. Okay, then Central Election Commissioner. So the point is, even though it is of union, it is a constitutional body, yet there is, in the appointment, complete say was there of the union government until recent judgment of the Supreme Court in April 2023, when the Supreme Court said that leader of opposition should also be given some say. Nonetheless, states still don't have any say in it, right? So again, I said until recently, but I take back my words. States do not have any say in the reformed criteria for the appointment of judges also. So bear this in mind. Now, election commission part is done. Another side information is the expenditure of election commission is not charged on the consolidated fund of India. Okay, expenditure is not charged. Any type of emergency in the nation converts the government into a unitary form. To a great extent it is true, so we will mark it as right. Okay, the CAG who audits the central and state government's accounts is appointed and removed by the president only, without the concurrence or without any iota of even the semblance of the consultation is not there. Even the formality sake, this thing is not happening. The members of IAS, IPS and IFS are recruited and appointed by, trained by the centre DOPT and their cadre controlling authorities are union ministries only. States can only suspend the IAS officer, IPS officer, or any All India Service officer, including the Forest Service officers, only for a maximum period of 15 days, within which the state government has to send the file to DOPT, the cadre controlling authority for IAS, and Ministry of Home Affairs Union for IPS. Likewise, Ministry of Environment and Forest for Indian Forest officers. The Constitution provides for a dual government. Now, what are the federal features? We are going to talk about federal features. Earlier, we have covered unitary features. Okay, unitary features, then federal features. Constitution prescribes the structure and functioning of the central and the state governments and the limits within which they must function. Constitution prescribes the structure and functioning of the central and the state governments and the limits within which they must function. So this is there. This is basically talking about Article 83. The center can, the union executive, the power of the union executive extends to the matters on which union parliament can make laws. Okay, so synchronicity between the power of the union executive and union parliament has been arrived at by inserting Article 83, which says that union parliament or union government can exercise its executive powers on all those matters on which union parliament can make laws. So this is union executive, union parliament. Synchronicity or coterminous powers are there with regard to the subject matters on which they can, parliament can legislate on the same matters the union government can execute. Can have administrative powers. The federal features of the constitution can only be amended jointly by the center and the states. I quickly ask you, which article deals with the joint sitting of the parliament? Which article deals with the joint sitting of the parliament? Number 2 question is it necessary to approve the is it necessary to pass the resolution, that the resolution around the president's address to both the houses, opening address of the president before the budget is presented, should be passed by both the houses? What if Rajya Sabha does not pass it? Will the government fall, or will it act like a censure motion? That's it. Will it amount to no confidence motion in Lok Sabha or not? 3 questions bundled in one statement. So please answer these questions when you listen to this lecture. That motivates me to come further with such kind of brain teasers in the middle of the lecture itself, right? So all subjects are divided into central, state and concurrent list. Which article deals with it? Even though articles are not asked, but you should remember Article 246 and this is Article 108, right? So with the center and the states, this is there. Now, federal features. Rajya Sabha, which represents the people of the states, act as the check on the powers of the Lok Sabha. Does Rajya Sabha act as the check on the powers of Lok Sabha? Yes, insofar as ordinary bills are concerned. Money bills, general bills are concerned. Money bills cannot be stopped by Rajya Sabha. In the system that we have, Lok Sabha has got an upper hand and Rajya Sabha has got a lower hand with regard to money bills. Now, the integrated and independent judiciary should be viewed as a protection of federal features only. We have a written constitution to protect federal features that weighs in, that tilts in favor of, having written constitution is considered to be a feature of federal polities, federal systems only. Number 1. Number 2, integrated and independent judiciary to protect the rights of the courts, the states, when the Supreme Court sits as a federal court, like on the matters of governor, on the matters of anti-defection law, or on the matters of this non-release of money to the states from the share of, in the terms of share of GST or Union Finance Commission grants. All these matters, when the Supreme Court hears them, it is sitting as a federal court, and high courts can also pass their judgments on the conduct of governor, not convening the session of the Legislative Assembly as per the request of the State Council of Ministers, under which article? Article 1(6). Please mention the complete article. Okay, so the judiciary also ensures that the center and the state governments operate within their jurisdiction by the power of judicial review. So having independent and integrated judiciary acts in favor of federalism in India. Now, 2017 prelims question we have already seen. Which one of the following is not a feature of federalism? it has an independent judiciary. This is in favor. So we just saw the topic judicial independence, and related question is here in front of you. Now coming here, center-state relations. Center-state relations are divided in this part 11, part 12. So part 11, part 12, memorize to the extent possible. Legislative relations are given between Article 245 and Article 255. Administrative relations 256 to 63. Financial relations 268 to 93. Financial relations have been amended drastically after the GST has come into implementation, right? So we shall deal with that in the next class. Today we are going to deal with legislative relations. Part 11, Article 245 to 255. Can be studied under two heads: territory over which the center and states legislate, union list, state list, then distribution of legislative subjects, another area. Here, territory of the center and the state legislate. The parliament can make laws for the whole or any part of the territory of India. A state legislature can make laws for the whole or any part of the state. A state legislature can make laws for the whole or any part of the state, right? Parliament alone can make extraterritorial legislation. Okay, Article 307 for interstate commerce, for the trade and commerce between two states. So this entry deals with it for one example only. It could be water, it could be railway line, it could be anything dealing with interstate, extraterritorial. Beyond the territory of India also, Parliament alone can make laws. Okay, you can say that the coastal waters, okay, high waters of India, then exclusive economic zone area, only Parliament can make laws around those subjects. Now, restrictions on territorial jurisdiction. The President can make, repeal or amend any act of the Parliament for the peace, progress and good government of the 4 union territories: Andaman and Nicobar, Lakshadweep, Dadra and Nagar Haveli and Daman and Diu. Then Governor can regulate the laws applicable to the scheduled areas. Schedule 5, Governor has got more powers. President can regulate laws applicable to tribal areas, the same power which is available to Assam Governor. So this is there. Now, expansion of the central legislative power. In the national interest, if the Parliament wants to get more power to even legislate upon the subjects given in the state list, this can be done by a resolution passed by Rajya Sabha by 2/3 of the members present and voting. 2/3 of the members present and voting, not the total strength. Okay, 2/3 of those who are present on a given day when the resolution is taken up for the voting. If 100 members are present, then 67 members should vote in favor of it. Okay, then the Parliament can make laws for the subject given in the state list, and this resolution is valid for 1 year and can be renewed n number of times. Okay, now the resolution becomes invalid on the expiry of 6 months after it ceases to be in force. Article 249 deals with it. The resolution becomes invalid. And what will happen to the law that was passed under this provision? This is what we are talking about. 1 year law can be passed, okay, and if such a law is passed, it can survive for a maximum of 1 year and 6 months as is written here. Okay. Now, proclamation of emergency. During an emergency declared by the President, Parliament can make laws on the subjects in the state list. During emergency, this is in the national interest. If no emergency is prevalent, no emergency is in force, 2/3 of the members can pass the resolution of Rajya Sabha to enable the Parliament to enact such a law in the national interest. During emergency, Parliament can make any law on the subjects in the state list which ceases on the expiry of 6 months. Here also 6 months, here also 6 months. 6 months after the emergency comes to an end. If the emergency is for 18 months, if the emergency lasts for 18 months, then this law will survive for 2 years. Okay, if the law was passed by the Parliament on the very first day of implementation of emergency. Now, what type of emergency? During an emergency declared by the President. So that means national emergency. Okay, under GST Act, Article 249 and 250 was amended to enable the Parliament to make laws with respect to GST in the national interest. So this is the third scenario. Scenario 1, Scenario 2, Scenario 3. GST, the financial arena. Emergency, national interest. Now, expansion of the central legislative powers, agreement. Fourth scenario is if the two states agree together that they are too small and they don't want to pass a law and they want some common area of conflict, area of mines maybe, okay, to be regulated jointly, then the center can pass a union parliament can pass a law if the two states pass a resolution to that effect. Resolution will clearly mention that they want the parliament to legislate on the matter given in the state list for their common interest. All right, so this is there. Then the parliament shall do so for such states only. It can be adopted by any other state. Yes, state can pass a resolution. If third state wants to adopt the same law, the third state can by passing a resolution to that effect. So 252. Okay, implementation of treaties. Parliament can legislate on any state subject for implementing treaties or international agreements and conventions. Article 253 deals with it. Then president's rule. When a proclamation for failure of constitutional machinery in the state is declared, which is this article, article 356 we are talking about. 356. Okay, so then powers of the state legislature are taken over by the Parliament of India. Earlier it used to be the president. President will pass the executive orders, the president's order to govern or to legislate upon any matter in the state list. After the rampant misuse, okay, of the emergency president's rule provision of the article 356, the amendment was so made that now only the parliament can legislate on the subject given in the state list, even during the president's rule in the state. Am I clear to everyone? So this is there. Now, three lists are there: distribution of legislative power, union list 100 subjects, then state list 61, concurrent list 52, residuary subjects which are not mentioned in any of the three lists and are identified later on are given in the realm of the powers of Union Parliament. Union Parliament can alone pass a law on the residuary subjects. So they will belong to the Union Government and Union Parliament. Whether a matter falls under residuary legislation is decided by the courts these days. However, the original constitution says whether a matter falls in the residuary list or not will be decided by the Union Parliament itself. Right? So courts have, as they have clouded over every area of legislation, administration. So this has been modified now. This is the practical side of our constitution, but theoretically it is the Union Parliament which decides as to which subject is residuary or not. Now, cases of conflict, union versus state list. Union list will prevail. In case there is a conflict between, pardon me, which subject is there, who is going to legislate. In case there is a conflict between union list and state list, insofar as the powers distribution is concerned, union list will prevail. Union law will prevail rather. Okay. Then union list versus concurrent list, union law will prevail. Concurrent list versus state list. Now to resolve this second point, this one, governor can reserve the bill passed by the state legislature for president's consideration. Article 201 basically, precisely, right? Center versus states in concurrent list, central law prevails. Then exception is if the bill reserved by the governor for president's consideration receives the signature, then state law prevails provided the parliament does not make any law to override it. Article 254 clause 2. So this is there. I am giving you an example. POCSO Act, Protection of Children from Sexual Offences Act. Some states made stringent provisions under the POCSO Act, which was for the first time passed by Union Parliament in 2012, applicable pan-India. But in the rise of increasing cases of molestation against children between 0 to 12 years of age, okay, you can say 6 to 12 years of age, but up to 12 years of age, Haryana, Madhya Pradesh, Rajasthan, they amended the POCSO Act of Union Parliament by passing a law in the state legislature, passing a bill in the state legislature. That bill was sought to be reserved for president's consideration. Those state legislative assembly bills made a provision that anybody doing any kind of sexual crime, any crime against children between 0 to 12 years of age shall be subjected to death penalty. But the union law said that he will also be subjected to same provisions as anybody molesting or having committed some crime against children from 0 to 18 years. It was a vanilla law. The states amended it. Okay, so such bills are to be reserved by the governor. Now, Article 246 was inserted. A was inserted in the constitution that make laws with respect to goods and services tax. Okay, so this overall center state financial relations will cover in the next class on this topic again, federalism 2.0 or federalism class 2. The parliament acquires the power to legislate on any subject in the state list in the national interest. We have just seen 2/3 of its members present and voting. This question was there in the first initial slides also, first few slides also. Now this is their executive relations coexist with the legislative relations. Article 162, executive power of the state extends to territory. Now some of the articles can be memorized in this manner. 83, if you add somewhere 79 and somewhere it is another number. Okay, so 83 plus 79, if you add these two numbers, if you add 79 to the union article related to the union, you will get the article related to the state. Sorry, it is 162, right? List 2. Now article 73 deals with the same thing related to the union. Okay, it is 73, sorry, it is 89. Article 73 deals with this power of the union, then add 89 to this number and you will get the commensurate number for the union or the state. Subtract, you will get union, and add 89 to the union parliament's number, article number, you will get the commensurate number for the state legislature. Union has executive powers on the subjects on which the parliament can legislate. Done. Those that are conferred by any treaty or agreement. Ordinarily, the states have the executive power on subjects in the concurrent list, except those which are exclusively conferred on the union. Second, this first one is by the constitution, or second by a law of the parliament. If a law of the parliament has already been enacted and that law says that central government alone will be able to deal with that matter. For example, terrorism. Okay, so on that matter, the matter is there in the concurrent list. Let's say crime, criminology, jails and prisons. But if the central government, by passing a law, union parliament passes a law on a matter given in the concurrent list, and that law mentions that union executive, central government alone can exercise the administrative powers, then disregarding the fact that it is a concurrent matter, the power will be with the union government only. Okay, so this is there. Now for example, money laundering, these type of laws that are there, interstate crime, laws dealing with the interstate crime, they vest in the union government. The powers vest in the union government agencies, Enforcement Directorate, FEMA, Foreign Exchange Management Act, likewise. Or even though FEMA is of union list only. Now, executive powers over concurrent list conferred on the union by a law of the parliament. So, subjects that are specifically for the union, like right to fair compensation and transparency in Land Acquisition Act, industrial disputes, etc., conferred on the union by the constitution. Conferred on the union by the constitution to implement any international treaty or agreement. Here you can have the example of GST also. Okay, the rates of GST council, the rates of GST can be amended by concurrently by GST council only, not singly by the states or center. Now, directions to the states conferred on the union by the constitution. Center can give the directions to the states during normal times, during emergencies. Earlier we saw union parliament can legislate during normal times in the national interest, article 249, then in the times of emergency. Likewise, we are coming up over here, right? So directions to states in the normal times, article 256, compliance with the union laws and existing laws. Article 257, ensuring that the executive powers of union and state are not clashing. 257 clause 2, construction and maintenance of means of communication, maybe railway lines, etc., or BSNL lines, Bharat Sanchar Nigam Limited, or any other telecommunication network. So, or even the transport lines. Okay, so military importance, any aerodrome that is declared in a state vicinity, so those aerodromes are to be protected by the state government. Okay, canals, etc. Measures to be taken for the protection of railways. Railways is separately mentioned at 3. All right, communications here 257 clause 2. So ensuring that the executive powers of union and states do not clash in general 257 clause 1. 2. Construction of and maintenance of means of communication 257 clause 3. Railways specifically, because railways is an important means of transport and communication, you can say. Now directions to the states in normal times, article 339, drawing up and execution of schemes which are, let's say, essential for achievement of national development goals and then translating into sustainable development goals. Okay, flagship programs of government of India. Then 358A, to provide adequate facilities for instruction in mother tongue. To 350A, 351, Hindi language, for the promotion of development of Hindi language. 355, protect every state against external aggression and internal disturbance. If the center so wants, under this provision, center can deploy military or at least central armed paramilitary forces can be deployed in the state for the protection of state from the internal disturbance or armed aggression, right? Like in Punjab, BSF, the limit of jurisdiction for BSF has been increased in Punjab, Assam and West Bengal. Earlier it was 15 kilometers. Jurisdiction of BSF, Border Security Force, was 15 kilometers. Now it has been increased to 50 kilometers since 2021. Right, so this is to protect the state from drug menace, etc. We dealt with these issues in the daily current affairs class in the morning also, so that is what helps you to connect with the static topics. Now directions to states, earlier we saw in normal times, now we are seeing in emergencies. Article 353A, the manner in which the executive power is to be exercised. Article 356 clause 1, President assumes the executive power of the state when constitutional machinery in the state fails. When the chief minister acts in a manner which is prejudicial to which is not in sync with the constitution. Okay. Article 360, financial emergency. During national financial emergency, there is no provision for state emergency. Okay. But if the state's revenue deficit and debt is going very high, then financial emergency could be invoked for the state also. Now, all the bills, etc., all the expenses can be managed by the union parliament when the finances, the financial emergency has been imposed. Union can give directions for propriety and financial frugality. Okay, for observing the canons of propriety, canons of frugality, you can say. Okay, persons of serving in the connection with the affairs of state, etc. All the money bills of the states to which the provisions of Article 207 apply can be made to be reserved for the consideration of the president. Here we are talking about directions, so parliament is not coming into picture over here. Article 207, during the financial emergency, union government can give directions to the union president through the council of ministers can give directions to the state governments. Okay, so this is their executive relations in other situations. Here we have seen directions in emergency, direction in normal time, then executive relations. Cooperative federalism, Article 258, union with the consent of the state can entrust executive powers to that state government. Mutual coordination and cooperation. That is why the cooperative federalism is written here. The state government with the consent of the union government can entrust its executive power to the union government. State government requires the consent, union government requires the consent under Article 258. Now without consent, a parliamentary law, when it is government, G to G, then the consent is required. When it is P to G, parliament to state government, P to SG you can say, then parliamentary law will be required. Then consent is not required if in the interest of the nation, parliament is authorizing the central government to delegate its functions or duties to the state government with or without its consent. This is important, right? So this was the question. Quickly go through it. I mean, we have already seen it. Now 2004, these questions we have already seen. Now in the next class we will be dealing with administrative relations also and financial relations. Center state topic will be completed in 2 classes. This was all in today's Udaan session. I hope you enjoy these lectures. Do share your opinion in the comment section and do answer all the questions, guys. With that, I take your leave for the day. Tomorrow being Sunday, I mean, we are talking about 9th of February. There may be no class that will be uploaded, but Monday onwards, the series will go on regularly. Thank you. Bye-bye.